A fitness app just agreed to a $62 million settlement for its alleged deceptive and fraudulent auto renewal policies. What's going on, y'all? Attorney Tom here. In today's video, we are going to be covering the case of Noom, which sounds like a terrible app. For anybody who doesn't know what Noom is a diet and fitness app, and essentially what they were doing is running a free trial to get users on the platform. And the second the free trial ended, Noom would charge the clients for 8 months of their service.
I threw up.
And on top of that, the 8 months was non-refundable. And on top of that, their user interface made it extremely difficult for users to cancel their subscription or cancel the free trial. And when you put all of that together, that is almost certainly some form of fraud or a deceptive trade practice. And obviously, Noom somewhat agrees with that assessment because, they're agreeing to pay tens of millions of dollars to make this case go away.
Is everybody gone? Huh? Good.
But I find this case super interesting because I see it all the time. It is hard to cancel subscriptions on these apps. So what I want to explore in this video is what is the line between simply just making your app hard to subscribe to, but in a legal way, versus a way where the company gets sued for tens of millions of dollars. So as you can see here, Noom was accused of extracting up to 8 months of non-refundable payments totaling as much as $199 once its trial period expired. The complaint says that the defendants know that once they convince a consumer to try Noom, they can charge an exorbitant non-refundable advance fee as soon as the trial period expires. And most customers will be stuck paying the fee because Noom intentionally hinders a customer's ability to cancel the program and takes away the triggers that might otherwise spur a customer to action. And this is perhaps the funniest part. The complaint claims that the Noom co-founder boasts on his LinkedIn page of talking about psychology of decision-making class at Princeton and points to a presentation that he's given, which it says focuses on behavioral insights that Noom used in its deceptive enrollment trap. The presentation is full of terms that describe well-studied patterns of human behavior such as ability and trigger, the complaint says. I always find it hilarious when defendants figuratively shoot themselves in the foot by bragging about their deceptive trade practices or their negligence or their bad actions. I mean, dude, come on. Now, while I have never handled a class action about an auto renewal issue, it seems like from the articles and the complaint that it's the totality of everything. It's not necessarily that the app made it hard for users to unsubscribe to, and it's not necessarily that they charged 8 months in advance. But when you put everything together, it makes it detrimental to the user. And on top of all of that, when you're dealing with fraud or deceptive trade practice, often an aggravating factor on top of all of that is the defendant's mental state. Did they know what they were doing? Were they doing this on purpose? And when you have things like a LinkedIn post bragging about your ability to persuade or convince people to not unsubscribe, or purposely making it hard for cognitive purposes to unsubscribe to your app, that's going to make things much worse. So as I said at the beginning of this video, this was a class action, meaning if you were a Noom user, you could be entitled to money even if you were unaware of this lawsuit going on. It says here, individual payouts are expected to be approximately between $30 and $167 per person, which is pretty consistent with a class action settlement. I see the memes all the time online about class action settlements. Get your $1, get your $10, get your $12. That's kind of the point of a class action. The whole purpose of a class action is to make it economically feasible for the little guy to pursue justice against big corporations for microtransactions or microaggressions, for lack of better words. If you went to a lawyer and you said, hey, listen, this app Noom defrauded me for $30 to $167, a lawyer's gonna go, I'm really sorry that happened, but I'm not going to take this case on a contingency fee because I'm going to put thousands of hours into it for a $30 payout or for 33% of a $30 payout. Or on the other hand, they're going to say, okay, if you want to pursue this, you're going to pay me $500 an hour for thousands of hours worth of work. And guess what? You're not going to do that because you're not going to pay $1 million to recoup $167. So what class actions do is allow people who would otherwise not be able to bring legal action to sue these big corporations together to make it economically feasible to pursue litigation. That's why 99% of the time these class actions have relatively low payouts like this, because that's the purpose of them. Because if it was a bigger case, it presumably wouldn't be a class action because you could get a lawyer to take the case on its own. But now I want to conclude this video with the following question. What apps have you experienced that have had non-renewal or auto renewal services? I see this all the time in my personal life, and I want to know what y'all's thoughts are. Tell me who we should sue next. Let me know, because you know, I'm a lawyer and I want to make a lot of money. The blimp's I got to pay for the blimp somehow. So let me know in the comments if there's any apps that charged you or make it really hard to unsubscribe to, and you know, maybe we'll look into it. And I'm only half kidding with that, by the way. All right, y'all, that's it for today's video. Talk to you later. Bye.
He's a catastrophic injury attorney who accidentally became a YouTuber. Attorney Tom.